Good morning. My name is Stephen Colby, and welcome to my webinar, How to Avoid an Intellectual Property Disaster. I want to start off by thanking our hosts, Idea to IPO. Without Rob and his work, this wouldn't be happening. So thanks very much. Today, I'm going to be talking about IP, and my talk is directed at typically early stage startups. These are companies that hope to get funding and grow and get big and maybe someday get bought for a lot of money. My job is to help you do that. A little bit about myself. I am a patent attorney. I've been working in law for about 25 years. Before that, I was the CTO of a tech company for most of the 90s. And was doing a lot of patents. And so I got into doing patent law because I was an inventor. So that's the history. I work for Ramon Law, which is a international law firm with offices in about a dozen countries. We're roughly 250 attorneys, and uh, we pretty much do everything. There's about 20 patent attorneys, but Ramon does everything else you can imagine a large law firm doing or medium-sized law firm doing, including corporate formations, fundraising. We represent a lot of venture groups, real estate, family law, white-collar crime, everything else under the sun. Uh, my practice, though, is primarily directed at doing intellectual property for early stage startups. Right. One final disclaimer. Listening to this webinar doesn't make you a client of mine, right? This is for informational purposes only. To become a client, there's some paperwork that has to be done. I am a California attorney, as well as a attorney licensed to practice in front of the USPTO. I am not an attorney in Germany or in Hong Kong or anywhere else. So if I say anything about law outside of the United States, please remember that. Um, I am going to talk for roughly an hour, and then I'm going to go to the question and answers tab. So that should be available to you. If you have questions, please put them in the questions and answers tab. And at the end of the webinar, I will go through as much of the questions as I can from that tab. If I get through that, then I will move on to the chat. But start with questions in the questions and answers tab, please. All right, let's start. You should see a slide. If you don't see a slide, scream, because it should say how to avoid. Oh no, are we sharing? Ha ha ha. Wait, I forgot something. Share. Screen one, screen two. There we go. It's not like I haven't done this before. Okay, now you should see a slide. So let me just move things around here. Okay, let's go to slide two. All right. This is gonna the title of this webinar is kind of how to avoid bad things. And there's a dark side to the IP. There's things that can go wrong in your startup, and you and your team might spend years and millions of dollars trying to put together a company, uh, only to have something come back and bite you. And my goal here in this webinar is to kind of maybe prevent some of those things, right? So there is a dark side. What you know can hurt you. Let me make sure I have the chat. Hold on. My cursor. So I'm using a strange computer setup. Okay. See my cursor. All right. Well, I can't see the chat. All right. I can see the question and answer tab. I at least have that up. Okay. So let's move on. So let's talk about some of the mistakes that you can make in developing a patent portfolio or doing a startup. All right. And I'm going to kind of go through each of these on a separate slide. And then I'm going to talk about, after I cover mistakes, I'm going to talk a little bit more about patents and what they're good for, right? So there's a positive side to this as well. So the 5 biggest mistakes are here. Number 1, 2, 3, 4, and 5. Number one and two, if you've noticed, are the same ownership, okay? Because that's because it's supposed to be there twice. There's two ways IP ownership can come back and cause you a lot of trouble, right? Waiting involves delaying your filings and not filing early enough. Four is about strategy, and five is kind of one of my pet peeves. It's really understanding what the patent does and what it can do for you. So let's go through these and look at them in a little bit more uh, in more detail. All right. The first thing you want to do is you want to make sure that you own your own IP, right? You want to make sure that things are developed at your company or in your business or in your project is owned by the entity, the company, right? And in the United States and in many other countries, there is a presumption that if somebody invents something, they own it, right? The inventor ownership starts with the inventor. And the law about this can vary. It can vary within the US states. Florida is a little bit different than California. Spain is definitely different than California. Right? In Spain, my understanding is that there's much more of a presumption that the company owns the intellectual property, right, by default. If you are based in Spain, you need to consult a Spanish attorney on this, all right? So in the US, what has to happen is the inventors have to assign the intellectual property to the company. And this can be done in a whole bunch of different ways. There could be an employment agreement or a contractor's agreement, which says, I agree to assign any inventions I have to the company. There could be a founders agreement, right? You've got starting a company and you have guys have a bunch, or gals, you have a bunch of ideas. And it's important that those you create a company, that you look for money for investors. It's important that those ideas, those inventions get assigned to the company. And the IP doesn't just have to be inventions. It can be copyright. So if somebody has designed the logo, one of your founders has designed the logo for your company, you have to make sure that that company actually owns that logo, because a year later, if that founder leaves, they may take the logo with them, right? So be very aware that anything that's developed, whether it's a website or logo or patent inventions or trade secrets or music, right? Anything, you want to make sure that you own it. And this should apply to everybody in the company, right? Even the salespeople, right? One of my favorite stories in this area is Adobe Forms, right? We have all had the experience of using Adobe Forms, and it's really cool and useful. And it was invented by a sales guy at Adobe, right? He was listening to what clients really wanted, their customers really wanted. And he said, hey, wouldn't it be great if we could have these fillable fields and you could design a form, right? So that inventor, I assume that Adobe got the patent, right? Uh, that was an inventor that wasn't from engineering, right? So every employee should have or every contractor should have some sort of assignment clause. If you're contracting with a company that does like app development, they're going to use tools that they use for all their customers. Let's say a shopping cart, right? So every client of theirs that has a shopping cart, they're going to use the same routines. So you have to negotiate a little bit about exactly what's getting assigned in that case. But the stuff that's unique to you should definitely be assigned to your company, right? There is an assignment process. Just like when you buy and sell a house, there's a government place in the government, mostly in the US, it's at a county level, where you record the sale of a house, and there's a deed that gets recorded at the county level. And anybody else who wants to go see who really owns that house can go look at the county recorder's office and see that sure enough, this house is owned by so-and-so, right? The same thing happens with intellectual property assignments with patents. There is an assignment that can be recorded at the patent office, and that establishes public knowledge that who owns or doesn't own a patent application or a patent, right? So make sure that gets done, even among you founders, right? your investors will want all the inventions assigned to the company they're investing in, right? That's part of their due diligence. Okay, so that's part one of owning your own IP. Part two is other people's IP. So again, there's two ways that ownership can kill you. This case, it's more an issue of you or employees bringing technology that's owned by somebody else into the company, right? So if I have an inventor that comes to me and says, I have this great new design chemistry for a solar panel, it's it's fantastic. It increases the uh, voltage output and the durability by so much. And by the way, it's a flexible panel that you can roll out. You can paint it on your car, whatever the invention is, right? And he'll tell me all, or she will tell me all about this invention. And I say, well, what do you do now? And they say, well, I work for a solar panel company designing solar panels, right? That's kind of the end of it, because that technology is very much likely owned by their existing employer. Now, this always raises the question, what if I am a solar panel engineer and I invent a new lawnmower? All right. And that varies in the US, that varies in state by state. Some states allow your employment agreement to say any invention that you come up with is owned by the company. Other states, California, for example, is much more strict. The invention has to be directly related to uh, the company's business, right? So the solar panel company doesn't get your invention on lawnmowers. In other states in the US, that might be a little more of an issue, okay? Um, so the trick is to make sure uh, when you're starting your own company, you have to do a clean break of some sort from your existing business. And usually people start companies in some area they're familiar with. There can be some history of inventions in the past that they have. They need to very clearly delineate stuff that was developed while they were at their prior employer and stuff that was developed after they left the prior employer. Okay. This is an issue, and you sometimes read about it in the newspaper. One big company will sue another for having poached a bunch of employees, and they're suing not only over inventorship on patents, but trade secrets, all these other things. So when you hire somebody, part of the hiring agreement should have language saying, you agree you will not bring any um, technology from your prior employers into my company. That gives you some protection, right? You at least tried. If that employee goes ahead and sticks some code that he developed at the last job into your app, he says, oh, I don't want to write this again. I'll just use what I used before. That could be a problem. You could be subject to copyright uh, claims, and that's something you definitely don't want, right? So you got to be clear with your employees what they can and can't do, right? One of the things that I always advise my clients about this, and something you can really do to help a lot, is keep good records, right? Um, Write down, take notes at your meetings, right? The best CEOs that I talk to, they come to a meeting and they flip open this bound notebook, a lab notebook, right? And they say, well, last time we talked, we covered all this, and you said you do this, 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 and oh, wonderful, it looks like you did, or whatever. Um, they have good records of all their meetings. Okay, and let me give you an example. Let's say you have a bunch of there's 3 or 4 of you around the table. You're trying to figure out a problem with your um, health app, and somebody comes up with this really great idea, or a couple of you come up with a really great idea. You write that down in your notebook, all right? And you've got a good record. You have a way of archiving this notebook. It's good evidence. And 3 months later, you hire somebody, Susan. You hire Susan from another a competitor, and a year after that, the competitor sues you for trade secret misappropriation. They say, "Hey, you hired Susan, and Susan brought this great idea that we now see in your product. Well, that was our trade secret, and we're suing you for millions of dollars," right? Which is bad news for a startup because just defending it costs a lot of money, right? Well, fortunately, you've got this notebook. 3 months before you hired Susan, 3 of you had this discussion, and in your notes it says, Andy and Don came up with this idea, and here's the details, boom. And that's all in your notebook. And that just brought a multi-million dollar litigation that could have killed your company down to something that might only cost you 25, 50,000 to defend because you have really good evidence. So there's lots of great reasons to keep good records. For me, it reminds me what I talked about with somebody 6 months ago, right? So it really helps. Before a meeting, I go back and I say, okay, what did we do at the last meeting? Did I promise something that I haven't done? Right. Um, that's important. Okay. Uh, One of the things about other people's IP is should you go out and search for it and look at what's there? Now, there's a difference between the startup viewpoint and a big company. If you're at a big company, they really don't want their employees to go searching the patent literature. Because if an employee finds something and is put on notice, quote, of the existence of a patent, that increases the liability of the company for infringing that patent, right? They're all of a sudden, this one employee sends an email to his immediate supervisor, says, hey, look at this. Man, somebody's got a patent on exactly what we're doing, right? And the supervisor says back, oh, forget that you ever saw that, right? Well, of course, that comes out later. And there's that it, the company can be subject to triple damages. It's really not good. So big companies generally don't like people poking around in the existing patents. Coming from a scientific background, right? I was taught to read literature, know what's going on in my field. I encourage my clients to go and look at patents. And the reasons are when you're an early stage startup, you're definitely not stuck in exactly what you're doing. You can twist and turn and go in a little bit direction. You can engineer around somebody else's patent in order to avoid infringing it, right? If you know about it at an early stage and you don't make that something that's irremovable from your product, you can work around it. The other important reason for looking in literature is you might find something, well, first of all, you might find something dead on and then decide, okay, I better do something else because, and that just saved you 2 years of your life because you knew about it earlier. It's better to know when you're a startup. You've invested less, right? The other thing that happens is when you read the literature, when you read other people's patents or their white papers and stuff, it gives you ideas, right? You may have a really cool way of doing something, and then you might read about somebody else's work and realize that the combination of your new really cool way and what they're doing is even better. Well, that's fantastic, right? So now you're going to write a patent on your really cool way, and you're going to write a patent on your really cool way plus your competitor's technology, right? The combination of those two things. And that's going to block the competitor, right? That's going to be a good strategy, good strategic. Right. The one more thing with open source, with other people's IP is open source. You can use open source materials, but you have to use, I mean, they're there for a reason. They're useful. It exists. If you're going to write a new shopping cart for an e-commerce site, by all means, find some pre-existing, well-tested system, right? The thing is, you have to read the open source license agreement. Some open source license agreements say, sure, use this. All right. If you find any bugs, please tell us about it. Right? Some of them say, if you use this, your product also has to be open source. Right. Or you can use this, but not for commercial purposes. Right. So those are all kinds of things that could show up in an open source license that can get you in trouble. And we have a president who got tripped up by this. You know, the Truth Social platform came out and had used a huge block of open source code. And they got a letter from the uh, organizer that was uh, providing that open source material and said, please send us all your source code because our license agreement says if you're going to use our stuff, your product has to be open source too. So they had to pull Truth Social out of the app stores, do a complete restart. It was many months before they came back and were able to release to launch again, right? Pretty much a disaster. Somebody who didn't listen to his attorneys. Who knew, right? So if you're going to use open source, make sure you talk to your attorneys about it. Have them look over the license agreement. All right. Next issue, timing, right? In the US and most of the world, it is a first to file world, right? So and I have seen very close, like a week, right? Where my client was a week at a filing date a week before the competitor, right? That can make a huge difference. It can make a big difference in the value of the companies, right? Um, Especially if you have direct competitors are doing something very similar. And this happens. You would be surprised. The reason it happens is, technology gets to a certain place, or people's business practices or thinking gets to a certain place that takes them to the next step. And very often that can happen with simultaneous people. I mean, Alexander Graham Bell invented the telephone, and he literally, there was a race to the patent office, meaning horses galloping, right? He got there hours, couple of hours before somebody else, right? And he got his patents in, and we know his name, and we associate him with the telephone. But somebody else also invented the telephone at exactly the same time, and it literally was a dash to the patent office, right? So this doesn't, there's no horses involved anymore, but you do want to get filings done as early as possible. There's another issue here in that if you use something public, you have a public disclosure, that can really diminish some of your rights. So for example, if you, I saw one question. There will be, everybody who's registered for this webinar will get a link to the recording sometime in the next few weeks. Yeah. Once it's ready, I will send it to everybody with a thank you note. So where was I? Yeah, you want to file before you make things public. If you have a public disclosure, that can eliminate your ability to get patent applications in most of the world, right? In the US, there's a 1-year exception. If you disclose your invention, you have a year to file the patent application on it, and your own disclosure can't be used against you. Of course, in that 1 year, somebody else might see your stuff, make further improvements on it, and et cetera, and cause you all kinds of trouble, right? But it is first to file in the US, right? So you want to get, after you disclose, you want to file pretty quickly. And a disclosure can be just a demo. There's a great piece of law. This law comes from the 1800s, where a man invented a new corset. This is a woman's corset that a woman would wear to help shape her figure, right? And he had an invention that involved placement of whale bones or something like that. And he put it on his wife, right? She put her petticoat and her clothing on top of it, and she went out into the streets and tried it out, see how it felt for a couple of days, right? Test it. And the court said that was public use. It wasn't that people could see the bones in the corset under her garments. It was that it affected the shape of her body, right? Her perceived profile, right? And the same thing now applies to an app. So if I go to a trade show and I show somebody on my phone, hey, I've got this really new AI app for manipulating images. Come and look at this. And I show them an example, right? That's showing not just what's on the screen, but the entire backend. Okay. Everything that went into making the results shown on the screen, it's considered public use of everything there, right? So this is a thing where I have clients get caught up. It's like, oh, well, we didn't really tell them anything about our back-end server architecture. But that was the child saying goodbye off to school. Yeah. But no, that was a public use of that back-end server architecture. So file early and file fast. In the US, we have something called provisional patent applications that can make it relatively inexpensive. And that is what I encourage startups to do. Even before you start pitching, before you start presenting, And before the end of this webinar, I'll give you, I think I have a slide on costs and how to manage this. But the trick is to get something on file um, so that you have a filing date before your disclosure, right? Okay, next thing. Boom. Okay, strategy. Yes, coordination here. The patents are for the sales and marketing people, not for engineering. Okay. Engineering gets their name on it, they get a little plaque, they put it on the wall, that's great. But for your company, the point of getting a patent is being able, there's two main reasons here. Okay. The first is so that when your sales and marketing people go out, they can say, we have these 3 fantastic features, and they're patent pending features. All right. They're patent pending features. Or we have these patented, right? We already have patents issued on it, right? That helps your sales and marketing team. The things that the key to a good patent strategy is that things that your sales and marketing people are telling customers why they need to buy your product, those are the same things you should get patents on, right? The thing that the engineer thinks is really cool, but doesn't really matter to the customers, I don't want to get a patent on that. I want to get a patent on the thing that's going to sell your product, right? So the patent strategy should be product driven. If you're a small startup with 2 founders, right, take off your engineering hat and put on your marketing hat and say, what is it that's going to make me a success? Why am I going to be the next unicorn? Why are people going to come charging to my door for my product? And you can come up with a few features, a few things that you've done. And you say, okay, I'm going to patent the technology that supports those features. So when you meet with a patent attorney, that's the kind of discussion you should have. The patent attorney says, why is your product good? What's going to make you a success? If he or she doesn't know that, then he doesn't know what to do patents on, right? So that's what should be the first thing. Why are you doing this? Okay. The second big thing on strategy is the why. The purpose of patents for early stage startup is to increase the valuation of your company, right? That's it. If you have a good patent portfolio, somebody might be willing to pay more for your company, or it might make the difference between getting bought and having a great exit and not getting bought, right? Most early stage startups exit by either failing or getting purchased. IPOs are rare, right? But even with an IPO, patents will make a difference, okay? If, as a patent attorney, I do my job right, that means that every time you raise money, the patent portfolio has paid for itself. When a company gets to their A or B rounds, I will actually sit down and make slides for their deck, showing in a really cool graphic. It's called a cluster map. I have a graphic that I can use that shows the relationship between those magic bullets, those things that make your startup really successful, and the IP strategy. I've got a nice graphic that does that. And the goal there is to make the IP more than just a checkbox, right? The goal of the patent attorney is to make your investors feel really good about giving you more money at great terms, okay? Patents for early stage startup are not the way to shut out competitors, unfortunately, right? So here's the reasons. First, it's going to be a few years before you get a patent application into a provisional patent application into an issued patent. And second, patent litigation is really expensive. So I have a case now that is years old, and it's over 8 years. Millions have been spent on this, right? And in legal fees, right? So if you're a startup and you become involved in patent litigation, you've probably transitioned from being a startup producing a product to being a patent enforcement company, right? Where you're going to go and sue people on your patents. And sometimes that's your better exit, but it's not as good. It's not the original goal. It's definitely not the goal of your investors, right? Unless they specialize in patent litigation. So the goal is not, if somebody asks you, what are you going to do about your competition? The answer is usually not, well, we've got this provisional patent application filed, because um, the idea that you're going to have a couple of $1 million to put aside to go into litigation, that's not really what your investor wants to see, right? A better answer to that question is telling them how you're going to get a first mover advantage, or you've got some trade secrets, or you've got some magic sauce that's going to give you a competitive advantage over somebody else, right? Your team is better. Okay. Um, so that's it. Okay, so that's strategy. And when you talk to your patent attorney, there should be a really in-depth discussion of strategy. It can be really important. All right, let's move on. Okay. Is this already it? No, that we went too far. Strategy? Did I miss something? Okay, understanding the patent. Yeah, no, I didn't. I got it. Okay, understanding the patent. This is number 5. So if you guys listening, if you want a more in-depth discussion of understanding the patent, I have a webinar, and I will send you if you reach out to me, connect with me on LinkedIn after today's event, I will send you the link to my talk on understanding the patent. And in that, I spend a full hour and a half or so going into details explaining the patent. The reason this is important is because a lot of people have misconceptions of what rights the patents give them, right? I have a patent, and there's a company in Taiwan that's infringing. I said, well, sorry, you have a German patent, and the company's in Taiwan, and you're an American company. So what's going on here, right? People think that having a patent gives them a right to do something, right? And that's not the case, okay? A product can be covered by many patents. If one of your competitors owns one of those patents, they can stop you from doing part of what your product is, right? So it's important. There are a bunch of different sections in the patent application, and they're listed here. There's the specification, there's the claims. Those are the two parts of the patent application that are most important. There's also drawings and abstract stuff like that. You need to understand what the differences are. The specification describes a bunch of technology, right? And somewhere in that specification is the invention, hopefully explained. The claims say what the patent owner or the applicant believes is new, is what's special to them, right? So I can have a 70-page patent specification with lots of stuff in it, and a set of 20 claims at the end. And the 20 claims might be focused on like one page of that 70, where the really important stuff is mentioned, okay? What happens is my client says, oh my God, I've read this patent. And first of all, what they're showing me is not a patent. It's a published patent application. Make sure you can tell the difference. It's clearly labeled on the cover. Patent publication or patent application publication versus patent, okay? A published application is only an application that has not been approved, right? So they'll look at a patent or an application and say, oh my God, they've written here all about stuff that's been in the patent office is horrible. Look at this disclosure includes stuff that I did back in school, right? It's got all this stuff, and they're going page after page of this whole system is horrible. How can people own this? Nobody can start a company anymore, right? And then you would go to the claims, right? And I look at the claims and I say, oh my gosh, these are incredibly narrow claims. To infringe this patent, you have to do every single thing that's in the claim 1, in one of the independent claims. And I sit through there with my client. I say, okay, do you do this? No. Do you do this? No. Do you do this? No. But they say, oh, but that's in the specification. I say, but that's not in the claims, right? It's the claims that say what the patent covers and has the right to exclude. The purpose of the specification is to explain what the claims mean, right? So there could be a lot of background stuff. There could be, the patent could be one of a family. So come and go look at my other webinar, and I'll talk to you about what patent families are. It means that there could be one specification that has lots of inventions in it, and each of those inventions is in a different claim set, in a different patent that are related to each other, right? So it could be that they filed a huge patent application and after some time figured out, okay, only these two things are really new, right? And those are what we're going to have our claims on. We're going to get a patent. A lot of the text in the specification is prior art, right? But it's the claims stuff that has to be new, right? So we can talk about that. Uh, Within patent families, in the US, it's very useful. You don't have quite so many choices outside the US, but you can file a patent application that claims a priority to a prior application, which claims priority to another prior application. So they can have a patent application I file tomorrow can have a great grandmother, right? It can go back 10 years. And I can still go after that priority date and go after inventions there that I hadn't claimed before. So you need to understand how the priority system works in patents. It's a little less flexible in other countries, but still you can go back quite a ways with priority claims. All right, that's it. Understanding the patent, important. It helps um, for somebody who's a decision maker in a startup, or even if you're working for a large company that you somehow get involved with patents, understanding what the patent really does is a great idea. Okay, next thing. Okay, this is a cool one. So I kind of touched on this a little bit earlier. Uh, Now we get to talk about the good side, right? I talked about the mistakes and the things that can cause a disaster, but I'm not only going to talk about that because I want something positive, right? Patents can make you a lot richer, right? And as a startup, the way you're trying to do that is you're going to found a company, hire people, create a product or service, and make happy customers who are willing to pay you, and then hopefully have a good exit, whether it's an IPO or getting bought by Apple, Google, Facebook, or Amazon, right? Somebody. Uh, that patent portfolio can make a big difference. And I have seen cases where there were several competitors that could have been bought, and one big acquirer. And the big acquirer paid hundreds of millions of dollars for one of them, and the other one went out of business, the other startup. Okay. So, sorry, phone coming in, call coming in. So it wasn't the only deciding factor. In the case for a client I'm thinking of, the CEO of my client who got bought for a lot of money was a really great guy. He was wonderful to work with. He was nice. He was the type of person, in the acquisition, they required the main engineering team to stay on for a year, so to help with the transition, right? These are the people they wanted, right? It was a good team. The competitor wasn't, okay? So it wasn't the patent portfolio wasn't the only thing, but it made a big difference in which company got bought. And in that case, it made to the inventors, to the founders, it made a huge difference to their pocketbook. So don't just drop IP. Keep it in mind. And while it might be an expense to your startup earlier, if it's done right, it's going to it can make a big difference to your exit, right? Think about it. If you're a big company and you've got this tiny little startup, I've had startups get bought in less than a year from founding to exit, right? They're still just two guys, okay? And they had some IP. And so the startup, the company that bought them, the one I'm thinking of right now was Google, was the acquirer. And it bought this startup. It asked the founders to stay on for quite a while. And it made a big difference. What was I going to say? So the startup, these guys exited really quickly, and the company could have said, "Oh, these guys put this together in 11 months. We have 50 engineers we could throw at it and do everything they can in 3 months, right? Why would we pay a bunch of money for it?" Well, the answer was there was a bunch of provisional patent applications filed that really covered things well. Okay. And so the decision for Google was, should we buy these guys or, and then develop this product and take the risk that someday we'll get sued for patent infringement on patent and, you know, pay out lots more money, or should we buy them? And this is a spreadsheet decision, right? What's the risks? What's the rewards? And for my client, fortunately, because they had IP, they got bought, right? And they had to work for Apple for a year, or for Google for a year afterwards. And I'm not going to tell you what product it is, but it's a Google product that we use every day. So it was an important one for Google. All right. Next thing. Okay, why? Yes, I think I just covered this, right? I love the graphic. You're the little white thing, and your acquire is the big blue fish. Now, in reality, hey, little guy, the next question is what's for lunch, right? The little guy's for lunch, right? I think this graphic is perfect for the startup acquisition product process. Okay, you're dealing with a very big fish, and you're the little one. So uh, I'm just going to repeat myself and say the reason that you're going to want to put money into a startup or into IP as an early stage startup is so that this encounter with the big fish turns out to be really good for you. Okay, it'll make it a big difference in your pocketbook. Okay, let's move on here. Next thing. What do I got? Okay, let's talk a little bit. I've been talking about patent. I am a patent attorney. I confess to it. Uh, but there's other things that you're going to get, right? You will have copyrights, almost certainly. You will have material that your company produces that's copyrightable. It might be a instruction book. It might be your website. It might be a flyer that you give to salespeople, right? So copyright is covers things like the music or the performance of music or software code or a, 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 a logo, right? If you get a logo on Fiverr, right? You you hire somebody on Fiverr for $40 and say, give me 50 logos for a company with this name in this space, and they come back with something really great, right? On Fiverr, there's a checkbox. And if you don't check that box says, I want the IP rights to whatever I get, right? And the designer who's, in the Philippines or something, if you don't check that box, they still own the copyright to your logo, right? And 10 years later, they're going to come along and you're going to pay. It's not good, right? So be aware of these things, right? Again, this is an example of making sure that you own your own IP, okay? Every little agreement. Um, Copyright, you don't have to register it until you want to enforce it. If it's something really important like a logo, you might want to consider registering. It's very inexpensive. It's done at the Library of Congress. Um, that can be done, right? Uh, my first slide had a little copyright symbol on it, right? That's me telling the world that my slide deck is copyrighted. Okay. Um, Trademarks. Trademarks are to represent goods and services, not necessarily your company, but let's say your app or your new high-tech tennis shoe or that sewing machine you've invented. Okay. So you don't need to do trademarks quite as urgently as patents. My advice on, because it's not a filing date thing so much, it's a first date of use for most countries, the biggest exception is China. But a trademark, you can get initial rights just by putting the little TM, right? You've all seen trademarks either marked with a circle R or circle S for a service mark or a little TM. You can put a TM on your company product name on your website today, right? Write down the date you did it, make a copy of that page and store it away somewhere, right? That gives you initial common law rights. You are the first to use that trademark, right? As time goes by and as your budget permits, you can go ahead and file a trademark application on that and declare your first date of use back quite a ways, right? We've been using this for 2 years. Don't wait that long, but that first date of use uh, does does matter. And that's the trademark side. If you come up with a really fantastic slogan or name that really knock your socks off, then increase the priority. But trademarks are going to cost you a few $1,000s. Trade secrets. You can get trade secrets, right? Sometimes you hear about Google or Apple and Samsung fighting over, or some self-driving car company fighting over trade secrets. The key to making good trade secrets is to write them down and establish them as trade secrets through some sort of formal process, right? This means making a list of your trade secrets, writing a one-page description of each of them, actually taking steps in your company so that access to the trade secrets is restricted, so that your front desk receptionist doesn't get to see, can't just log in and see the secret code, right? Or can't see your customer list or your pricing, your confidential pricing schedules, right? Your pricing formulas, right? These are all examples. Anything that you keep secret that has economic value can be a trade secret. So it's not just something techie. It's the sales list, right? It's the you know, the customer, the prices that you're charging. Maybe you're charging different customers different prices, right? Depending on how good a sales guy you had, right? So it's definitely a trade secret because you don't want to find one customer to find out they've been paying twice as much as the other one. The details of your contracts with other people, those can all be trade secrets. So a good trade secret program is managed by keeping track of what is and what isn't a trade secret, limiting access, right? When somebody gets access to a trade secret, it's a documented thing. Andy, you now have access to this trade secret. It is a trade secret. Sign this document here saying that I acknowledge that it's a trade secret. And then when Andy leaves, remind Andy, here's the 3 trade secrets you had access to. You are forever bound not to reveal those unless they become public some other way, right? So that's a good trade secret program. And I like it in some ways because I also feel sorry for the engineer who's like, oh, I have this new problem. Oh, I solved that problem 6 years ago at this other company. Yeah, what did we do? Oh, yeah. Boom, right? Oh, that was a trade secret? I forgot. Right? Right? So you want to make the trade secret something tangible. And the biggest defense in a trade secret litigation is, oh, that wasn't a trade secret. People talked about that all the time. The sales guys were talking to the customers. Everybody knew it, right? It was wink, wink, a trade secret, right? Um, that's a big defense. And if you have a system where you really keep track of stuff, you can say, oh no, look, it was well established. Everybody knew this was a secret. Okay. Patents. Patents are my favorite. They're often, not always, the most valuable type of IP a startup will get. And let's talk about patents a little bit. All right. Um, this is a list of common patents and patent applications. There is a difference, folks. It 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 um, it bugs me. Sorry, it bugs me when a client says, "My competitor has 6 patents." It's like, wait, they just no, those are patent applications published, right? Um, that's not a patent yet. Okay, so there's a difference. You should refer to an application as a patent application or a application, and only something that's actually issued as a patent as a patent. Okay? A provisional is a type of application, a provisional patent application. Okay? It is very convenient and very nice and used a lot by startups because it's less expensive. It's basically a placeholder. Let me give you an example of a placeholder. You are about to give a big presentation to a set of investors. In that presentation, you're going to give a quick demo of your really cool app, right? That you really want the investors to see. As I told you earlier, that demo of the app is actually potentially a public use of uh, of the whole back end, right? So what are you going to do? You're going to take that slide deck and a white paper or design document that you've written about your back end, and you're going to take those things, slap a cover sheet on it, and file it with the patent office. That's a placeholder. You get credit for the filing date that you filed those papers for whatever is in those papers, right? And so very often the pitch deck gets added to a provisional somewhere, right? Just to make sure that we can say, oh no, we filed that before the presentation, okay? So that's very useful. It's quick and easy. It can be a very carefully prepared, substantial, meaty document, or it can just be a slide deck, right? It's inexpensive. The filing fee for a small entity is $130. It doesn't take long for a patent attorney to do it. It only lasts 1 year. 1 year and a day after, it goes away. If you haven't acted to in what we call claim priority from that provisional, it's like it never happened. It's never going to publish. It's going to stay secret, but you'll lose the advantage of that filing. In order to take advantage of that filing, you have to file a non-provisional patent application. This is the type of application that will turn into a patent, a utility patent, right? And there's a statement when in the paperwork with the filing of that non-provisional that says, I want to claim priority to all these provisionals I filed in the last 12 months, right? And I've seen many provisionals, hundreds, in some strange cases. But you can file one non-provisional application that claims priority to 3 or 4 provisionals you filed over the last year. It has to be done within the year of the first one. That preserves the right of everything that's in those provisionals, right? The non-provisional application is an application you hope will turn into a patent, right? After an examination process, it will hopefully issue as a patent. Maybe it will be the start of a whole family of patents, applications, and then patents. It will last 20 years from typically 20 years from the filing of the non-provisional application, if you pay all the fees and so on, right? It costs a lot more, right? So I will talk about, I think I have a slide on costs, right? It costs a lot more. Hopefully you've gotten funding. A provisional application is something that's easy to do out of pocket, right? You are raising money, spending your boyfriend's credit card, whatever. You can get a provisional application done for a few $1,000s. Non-provisional, you're looking at more like tens of thousands. Well, let's see. One more thing on types of applications. Occasionally, I'll have a client that does a design application. Design applications are supposed to cover the ornamental aspects of something. Good examples, the shape of the brawn electric toothbrush, a car hubcap, right? One design application I did when I first started in law, I didn't do it, but was the shape of the Polycom speakerphone. This is always a great example because usually when I'm talking one-on-one with clients, we're in a conference room and there's a speakerphone on the table. So that triangular shape of the Polycom speakerphone had a design application covered it. And that design application was used, it was litigated. They knocked competitors out because it turns out that you want to have microphones out on an outer edge and a big speaker in the middle. And so kind of the competitive shape is a big flying saucer, which looks ugly and huge on a table. And that sleek design of the triangle was much better. So Polycom had that. That's a good example of a tech company making great use of a design patent. There's design patents on, Apple and Samsung have been fighting in the recent years over design applications relating to their phones, for instance. Okay, it's moderate cost. The main cost is doing drawings. Right? Okay. Let's see. That's common types. Oh yes, a little bit about international. Patents are country specific, right? A U.S. patent is enforceable in the U.S. If it is an app on the App Store and the server is in Europe, there's a good chance that you'll still be able to enforce it in the US because the use is actually occurring in the US, but that's on a case by case, you've got to look at the details thing, right? There are patent regions, so there is a patent office that covers all of Europe. Right now, if you go through that process and are successful, you go through one examination process, but then you end up with an Italian patent, a UK patent, a Swiss patent, and a German patent. That is in the future looking more and more likely it'll change. There's going to be one EPO-wide patent where you get a European patent. So that's changing. You can now get a patent and register it over the whole EPO, and we've starting to see that happen. Okay, but again, if you want coverage in lots of places, you have to sit down with your patent attorney and decide what criteria. Where are your customers? Where are people likely to manufacture the product? Who's going to acquire you, right? If you're going to be bought by Toyota, then getting a patent in Japan will make a difference to Toyota. They might pay more for you because you've got IP in Japan. Okay. The only companies that do a lot of worldwide patenting are pharmaceutical companies, right? Everybody else picks their top choices. And for an early stage startup, if you're in the US and Europe and maybe one or two countries in Asia, that's almost always enough, right? Having an extra patent in Singapore is less likely to be ground shaking. Right? And they're expensive. Every one you do, you're not only paying for US attorneys, but you're paying for attorneys in Germany or in Hong Kong or in Sydney, right? So the costs really can add up. It's a better strategy to do more patents in a small number of countries than to try to do one patent in lots of countries around the world. Right? All right, cost, yes. Not everybody will show you this. This is a approximation average. Your experience will definitely vary. All right, so I have historically looked over what it takes to get out of and I am a Silicon Valley patent attorney. I mean, of that type. I I work in Reno most of the time, but I service companies in Silicon Valley, and I started my practice in Silicon Valley, and my law firm was originally founded in Silicon Valley. So most of my clients are Silicon Valley type startups. But a provisional application, 2,500, 3,000 maybe, right? That is inexpensive because it's the attorney working with you, helping you. I do a program where I'll meet with the inventors for an hour and a half or so, figure out the business and the invention. I'll write a set of claims, a summary, maybe some drawings, and I will take those claims, turn them into an outline, and hand them to the inventors and say, fill this in, right? And I get all kinds of stuff back. But hopefully they do a good job writing and they can turn that into a substantial disclosure, right? Then we do a couple of drafts back and forth, right? And sometimes there's some hand holding, but that's about $2,500, $3,000. Okay. So that gets you your initial filing date. It protects your company. It's the type of thing you can do before you start raising money. Right? A non-provisional application written by an experienced patent attorney is going to cost you to get the application on file for the original application close to $20,000, right? It might be 15, it might be, it's very much, you're paying somebody to write. And I charge by the page, other attorneys charge by the hour. It's about the same. The more the attorney puts into it, the more valuable. I have had patents and patent applications where one paragraph turned out to be like the magic that we put that paragraph in, and that 4 years later we're going, oh my God, thank God we put that one paragraph in. So the more material you have in your specification, the better. But then it's cost. I could write 100 pages, but that would be hugely expensive, right? So for a normal run-of-the-mill average patent application, you're looking, including the filing fees for an early stage startup, 18, maybe $20,000. And that's just to get it on file. There's then the examination process, and we have just a couple more slides here. The examination process. So more than 95% of applications are rejected in the first round. Your patent attorney has to then write a response explaining why do have the right to a patent. And we're not going to get into details of that. But an average patent application has a couple of those office actions, right? And then it may either die, or there might be more, or it might go to appeal, or who knows, right? There's all kinds of things that can happen. By the time you're done, you've probably put at least $30,000 into your first patent application for it to issue, right? Including some of the fees. But that's a ballpark. Again, your numbers will vary. The goal here is between the filing of your provisional and the filing of your non-provisional, you've raised $500,000 or $1 million for your company, right? And so this is an expected expense that your investors are going to want to see. Right? I tell an early stage startup, if you put in your budget 35 to 50,000 for IP in your first year, and you're a tech company, right? That should be okay with your investors. Yeah, that's a reasonable number. It depends a lot on how aggressive you're going to be and how dependent on how important the IP is going to be to your company. But those are reasonable budgets post funding. Right? If you only raise 150, clearly there's going to be less money for patents. Now, I have two lines here in this picture. The other is family members. So I talked about there being the idea that you could have a specification, and it could have a patent application. You can have daughters and granddaughters and great granddaughters and so on. So if you've already written a big specification, and now you're going to file what's called a continuation application off of it with a different set of claims, you're focusing on a different invention in that specification. Most of the work's already done, right? So I've actually looked at clients of mine that have done dozens of patent applications, and it turns out that looking across both the original applications and the cons of various types, the cost of getting things on file drops under 10,000. $9 to $10,000 on average. Okay, meaning some were just a few $1,000s. So it gets easier as time goes by. All right, and certainly, for example, you might have a patent application. You might have a family of patent applications where the first three figures are all the same basic stuff, right? You don't have to pay for that over and over again. Right? It's the new stuff that's in each application that you have to pay for. All right. Let's see. We're past an hour here, so I'm going to try to go on. Okay, that's it. Yay! Good timing. All right. This is me. I work for Ramon Law. 45. It's now 12 countries. Well, we had an office in Moscow. We don't have that anymore. I got to update this one. And I don't think it's 45. It's probably less offices right now, but it varies. We are all over the world. If you're calling in from Israel, I think I saw Hebrew there a minute ago. We have an office in Tel Aviv. We also have an office in Dubai. Throughout Europe, several places in Germany, Italy, the UK, France, definitely. Then around the Pacific Rim, from Tokyo all the way down to Sydney, we pretty much cover a good part of the world. And again, we do everything, not just patents. We do for startups, corporate formations, safes, initial investments, founders agreements, corporate formation, creating your startup for you, all those kinds of services that we do. That's it. Please don't hesitate to reach out to me. You should be able to see my LinkedIn and my email there. And if you do reach out, I will send you the link to my talk on understanding the patent. Great. I'm now going to go through, and in the next 20, 25 minutes, I will go through the questions and answers, and hopefully, yes, I have control here. All right, starting at the top. Okay, the potential advantages and disadvantages of establishing a holding company to own patents. Cost. So like in California, the minimum, it's $800 a year. Over 10 years, that's $8,000, right? To keep a entity in good standing. Delaware has also annual fees. If you're talking about outside the United States, the fees will be much higher. If you're going to the Caymans or something, your investors, and this is probably even more important, your investors want to invest in the entity that owns the IP, right? So if everything goes to the pot, right? If the business is a disaster, one of the assets that's left over is patent, often is the patent portfolio. And the point is that you want to claim, I mean, that's an asset the investors will try to get a little bit of money back from, right? So when a company goes under, there's a scramble to sell the assets, and the a smart investor will make sure that the IP, the patents, are registered in whatever in the same entity that they're putting their money into. And if the investor misses that, you don't want this investor, they don't know what they're doing. Okay. So that's the deal about holding companies, right? Sometimes the investors will put money in the holding company, but then there's all kinds of issues about the follow. Is everybody going to put their money in the holding company? Why is there a holding company then? Right. So we'll see. Okay, next question is about the recording. Yes, I saw that. Can you patent your technology and make it open source? Yes, you definitely can. Um, you can patent part of it. There's an open source license. You can uh, make a requirement of the open source license that people acknowledge you and send flowers to your mother or whatever. You can do all kinds of stuff. Uh, part of it could be part of it could be open source, right? Good way to get users. And then the new things that you come up with on top of this open source platform that you've created and offered to the world, you can patent, right? And then now you've got 30,000 people on the platform, and you're going to charge some money for parts of it, extensions, right? So there's all kinds of business strategies, but you can definitely, if you give it away free and you have a patent on it, um, damages, then you try to litigate. A defense will be, well, this was free. Okay, there's no damage here of me infringing this patent without a license. It could be that the consideration for the license is something else. Like I agree that every employee in my car, or every employee, I will put charging stations for all my employees. That's my agreement. I'll get to use your software code on the condition that I put charging stations in. Okay, kind of weird, but yeah. And if they violate your patent, you get to sue them, spend $1 million in litigation, and get them to put charging stations. Okay, wacky example, but yeah, you can patent something and make it open source. And let's talk about OpenAI, right? Open source, or a nonprofit company wanting to turn into a profit company, right? There's definitely parts of their technology which are quote unquote open and parts that aren't. Okay. All right, let's move on. Is it possible to sterilize AI generated code so that it doesn't violate the copyright of others? Uh, so anything generated by an idea come up that's been generated by a AI is not patentable, right? We haven't fought this out in the courts completely, but they have in copyright. An image generated by an AI can't be copyrighted. Now, nobody has figured out what if the image is half copyrighted, half AI. If I drew a picture and I had an AI tweak it, is that copyrightable? That is not known yet. Okay. It was at 50-50. Were half the words mine, or 51% of the words mine? And there's no clear line. So if I write a book, right, if I write a story, a detective novel, and then I have an AI fix my style, right? So I don't sound like a patent attorney. I sound like a good author. Is what's copyrightable, right? So the plot was mine. So there's going to be all kinds of law that's unsettled. But the copyright covers, so to give an example, if I have an AI generate pictures, a still life with fruit, a bowl and a bunch of fruit. Okay. It's been trained on lots of fruit of paintings and images, right? And it's going to give me a bowl and a bunch of fruits, but that's not going to be the same probably as any others that it trained on. It's going to be just like the first guy who painted a picture of fruit and a bowl didn't own the rights to all fruit and bowl pictures, right? It became a theme that people painted on. Right? Sometimes you had a dead pheasant in there too, right? So if you have code that's generated with AI, um, you've probably told the code what to do. So the functionality which you would patent wasn't generated by the AI. The code itself is not copyrightable because it was AI generated, but I'm not worried about it being infringing on somebody else's code because it's probably pretty different than everybody else who wrote code to do that functionality. Right? Um, but I'd have to look at a specific case. But generally, I'm not worried about the copyright issue on code in terms of violating other people's. I'm worried about if my whole system, if 80% of my code base is AI generated and 20% is human generated, I can only copyright the 20%. Right? So that's the issue there. Okay, I have, Chiro asks, I have a granted patent with multiple claims that cover my hardware product. However, the product has evolved significantly during development. Is there any way to modify or expand the existing patent to cover these new aspects, or would I need to file a new patent application? You are probably, from what you've said here, going to file a new patent application. If you had filed the new patent application the day before your patent issued, then you could make them part of the same family, right? So your patent attorney should have said, okay, your patent's about to issue. Was there anything else developed in the last 3 years that's really close to this? Do we want to file a con, right? And the patent, and you might have said, yeah, we've got all these improvements. And the patent attorney would say, oh my gosh, we have 3 days to get those on file. Because as long as one application is pending, it can have daughters. Once it issues as a patent, it can't have daughters anymore. Now, there is some exceptions to this. Um, in terms of tweaking, you can have a reissue of a patent application. You can tweak your claims a little bit, but you can't add anything to the specification. So anything you change, excuse me, anything you change in the claims has to be fully supported by the specification. You can't come up with claims that weren't on stuff that weren't described in the original specification. Right? If you file a certain type of daughter application, though, you can. You can add some new material. That impacts your priority and filing dates, but it's possible. So in your case, you describe a granted patent. I'm assuming you mean an issued patent. If it's been granted and it's going to issue next week, then you still have a few days to file something, right? But definitely you've got to file something on at least that issue date. Okay. If it's now passed, hopefully your new stuff is original enough that you can get a new patent, even with your old patent being considered prior against you. Okay, so somebody's asking, why didn't trying the core set out in public represent an experiment? So there is an experimental exception to the public use rule, and that's when it really is an experiment. So a great historic case, it has to do with roadways. Okay, somebody puts asphalt on a road and they're trying different formulations for asphalt and they put it there for 10 years, but they have somebody coming out every month and making measurements, right, and collecting data. That's an experiment. Another great case in this field, in that area, is somebody who invented a new carburetor for outboard motors for boats, right? And he gave it to a bunch of friends and go try this out. Tell me what you think, right? And they tried it. That was public use because it wasn't an experiment. Okay, so in both those cases, use in public was required. Right, the motorboat. Now, to test the motorboat, you needed to find a completely private lake or use it out in the bay, right? So, and the roadway had to be public, right? You want millions of cars to go over it. So, but the core set, you could walk around the house, right? My argument would have been to do the experiment, you could have put it on and spent the day doing things around the house to see how it felt. Walking out in public part, wasn't necessary to do an experiment. Okay. Anyway, that would be my answer. But this was back in the 18, who knows what the law was like then. There may not even have been an experimental um, exception back then. But if you're going to do an experiment, you've got to document it and say, here's the test and here's the results and here's why it had to be in public. Blah, blah. Right. Okay. Okay. What can you do in your patent application to help avoid having your future issued patent overturned? Okay. Probably the best thing is to do a good job of describing everything well, and then have a wide range in the scope of your claims. Have some very narrow claims and some very broad claims. So if the broad claims are knocked out, the narrow ones can still stand. So if the validity of a patent is challenged in court, that's analyzed claim by claim, right? And so some claims may be knocked out. This claim was too broad, it goes away, but this narrow one, it still stands. And so that's a strategy in claim drafting. You want to have some nice broad claims that you'd be happy to get, but you also want to get claims that are, you know, much less likely to be knocked out. So that's a exercise in claim drafting, is to have both narrow and broad claims. Right? Um, um, prior art searches. I'm going to deal with this getting knocked out again. Most of my clients don't do prior art searches before um, uh, we file provisionals. Sometimes they do before the non-provisional because of the cost. Prior art searches are somewhat expensive. I mean, they can vary between $600 and $10,000, right? Depending on the quality. There's going to be art that you can't find even in the best search, meaning if somebody filed a patent application next month and it's still secret, or last month, right, a month ago, it's still secret, they have priority over what you're going to file tomorrow. The best search in the world won't find what they have, but they're going to have priority over you, right? So no search is going to be perfect. Getting the search done is one thing, and then having a patent attorney spend 20 hours reviewing the search and trying to figure things out, that's even more expensive. So I tell people to read the literature, know what your competitors are doing, go out as a startup and search yourself, go to Google Patents and see what you can find. And if you find stuff, make sure your patent attorney knows it and you work around it, right? Saying this is going to be prior right. Okay, well, let's change the focus of our claims a little bit to avoid that, right? Okay. Um, if an AI made your logo, you can still trademark it. Yeah, put a little TM next to your logo, right? It's the copyright. If you tell people that AI made your logo, um, there's a copyright issue. And I'm only talking US law here, right? Okay, so if you're going to try to get a copyright in Italy, it could be very different. And I don't know what the rule is in Italy about AI generated stuff, or China, right? Um, but you can definitely get a copyright on a trademark on it. Yeah. If you have a logo, focus on trademarking it. Right? Does any government look at your provisional application? No, they do not look at it, except in terms of national security. So if you file an application on a new um, weapon system that the U.S. decides they want, you're a U.S. inventor based in the U.S., okay, and you file something, anything you file, there's a very brief initial review um, for national security. So if the government and they can slap a secrecy act, there's a secrecy act. They can say, this is something we do not want public. All right, we're going to delay your patent for 20 years. You're then going to be negotiating for a license with the government, which may not be so bad, but it's rare, it happens. But I work in areas that are sometimes military related, autonomous vehicles, for instance, and haven't had have very rarely have had that a few times in 20 years, 25 years. But it can happen. And so the government will look at it for that purpose, but no other purpose. And a provisional can have multiple things. I've filed provisionals that have a technology about call handling and putting people on hold and RFID in the same document. I mean, there's just basically two documents I put together, and I wanted to save the $130, so I put one cover sheet on them and filed them together, right? So it's not reviewed. Is there a process for recipes being trademarked or trade secrets? So when you say recipe, I assume yes. Um, I assume you mean like a process, a chemical recipe for treating steel or how to make a fabric fireproof. That's what I mean when uh, Clint is saying recipes. So you can make a trade secret um, out of a recipe. That's very easy to do. This is the chemical process. We heat it to this. This is the acid we put in. We put a voltage of this amount through it for 25 minutes and then cool it down and we cover it with argon gas. Right. That's a recipe for materials processing. It could be a trade secret. Okay. In your question, being a trademark, a recipe wouldn't be a trademark. A trademark would be something like our name Ramon. Okay. Especially with the little red R. Oh, right. Um, so Ramon is a word. But so next one, and we are going to finish in 7 minutes. If I sit down with the business and learn more about their operations and pain points during the market discovery and use that as input to develop a generic solution for the market, could they have an IP claim on any feedback? Or no, probably not. And more likely, it's very common to interview businesses if they don't ask for a NDA and there's no expectation of confidentiality, then you're probably going to be okay. Now, if they invent something, right? Let's say you were Adobe and you're sitting down with a customer, you're Adobe sales guy, and the customer says, you know what I really wish was that you had forms. Like I could put blocks down on my Adobe document and they could be fillable, right? And it would be Adobe Forms, and you could lock forms and you could have ones that were required and all these other features. And the customer explains this all to the sales guy. And then the sales guy goes back to Adobe and said, this is not what happened, of course, and says, I have this great new idea. Let's patent it, right? That doesn't work. The inventor owns it. The inventor is the person who conceived of the concepts in the claims, right? It's the claims that matter again, and it's the conception. So an inventor is not a person who gets a requirements diagram and codes it and makes the product. The inventor is the guy who said, oh, let's use this clever approach in our app. Okay, and that got put in the requirements definition. That's the invention, the conception. And conception can be groupthink, right? You can have four people around a table exchanging ideas, and the end result is a group effort, and they're all inventors. Okay. Okay. If I sit down, okay. What if I come up with an idea through conversations with a friend, and they later try to sue, stating their own rights? Keep a so the question is, if I have a conversation with a friend or a thought it was a friend type, and they later try to sue stating they own rights in an IP, as they're involved in the conversations, this can happen, right? Um, uh, I've had people do it where they're taking, there's a conversation, there's somebody who's a note taker, and the note taker says, I was there during that conversation, I took all the notes, right? Roll the eyes. So this is a great example of keeping good records, right? So if you have a conversation with your friend, get it back on the next, go home and send them an email. I really liked what you did, our conversation today. Thank you so much. Um, uh, you know, you came up with blah, blah, blah to improve my ideas on blah, 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 right? So maybe they contributed something. So don't put that in the patent application. or in the claim, right? If they came up with, let's make it red. This is not something you'd actually claim, but they came up with a feature that's not really necessary, but kind of nice, or you could do it in a different way. Don't put that in the claims, and then they're not an inventor on your patent, right? They conceivably could go and file their own patent application, but that's not likely. So the issue here is, were they an inventor on your patent application? And you can control who is and who is an inventor by selectively claiming ideas that different people had, right? So if we have a situation where a employee left under bad circumstances, we might file, and they're, we were writing a patent application that we intended to have them as an inventor on, right? And all of a sudden there's issues. We might say, okay, these are the things they contributed. We're going to file an application without claiming those things, right? So they are not an inventor on that application. If we finally come to an agreement with them and things get worked out, then we might file a daughter application with their material, and they're going to execute assignment agreement assigning their invention to the company, right? So that's important. Um, but yeah, you can work around that if you strategize with your patent attorney. Okay. Um, for food recipes, okay, food recipes is coming back. Food recipes are generally not patentable, but I have done them. um, I have done manufactured meat, and I'll get, so a recipe like you'd find in a cookbook, not going to be patent. Going to be considered obvious. People have done things so many times. Um, I have, but I have done a food processing patent and gotten a patent out of it. It was a manufactured meat. It came out of Australia. Think spam. And the idea was people wanted a small ham. So a ham is a huge thing. I mean, right? A fully grown pig. But people want a little one, and they don't just grow baby pigs and kill them early so that you've got small ham legs, okay, with a bone in, right? A bone in ham. What they do is they take ham meat and they add spices and flavoring and salts, and they churn it all up in a machine, and then they take a turkey bone and they put the turkey bone in a press and they squeeze the meat around it, and it looks just like a ham. It's got the bone in, but the bone's not an actual pig bone. It's a turkey bone. And now you have this marinated and flavored meat around it. And you can go to your store, your next Thanksgiving, go and you'll see small hams. Okay, that's not from a small animal. That's from a big animal, and it's been um, reprocessed to look like a small animal. And the bone in there might be something else, right? So that's an example of patentable food technology, and it's pretty close to a recipe, but there was enough difference, something you wouldn't find in a cookbook, right? Using a bone from a different animal and the spice and the marinating steps and stuff like that. So you can get IP on food. I do lots of interesting food tech, but it's not the recipe that, like a recipe you'd find in a cookbook. That's something you could copyright. If you copyright it, somebody can write the recipe in a different way, right? Copyright doesn't, again, looking at a painting of a fruit in a bowl, okay? Your recipe is to take two oranges and a pineapple and put them in a bowl. Well, if somebody takes the oranges and pineapple and rearranges them a little bit, now you have a different picture. So it's different. It wouldn't be covered by the original copyright. So the book itself is copyrightable. The exact copy of the recipe is copyrightable. If you publish it online and somebody distributes it somewhere as your web as a copy of your web page, that's copyrightable. But the recipe itself, it wouldn't be a trademark, right? Because it's not representing a product or service. And it would probably not be patentable, right? Well, that's it. My time is up. I hope you guys enjoyed uh, the webinar, and please reach out to me on LinkedIn. Uh, Anybody who wants, I will send the link to my webinar on understanding the patent. Great. Thank you very much. That we got to do. Okay, hold on. Stopped recording. Stop share. All right.